Hi, everyone. I'm Emily Marsh from the Greater Concord Chamber of Commerce. Thank you for joining us for our webinar this morning. I just want to go over a few things before we kick things off. If you have additional questions right now, you can go to our website, concordnhchamber.com. We have a page of COVID resources with many links for you to take a look at. So please check that out. We will also be recording today's webinar and sharing that online afterwards and with everyone who registered to attend. If you have questions today, we can answer them for you. You'll submit them in our Q&A portal. So if you tap your screen or just move your mouse a little bit, you can click on Q&A, and from there you will just type in your question, and it can be seen by me and our presenters today. The attendees will not be able to see your question, so please use that so that we can answer some questions from you guys today. Just want to thank Orr Reno. They have been amazing working with us to present some really valuable webinars on urgent topics. So I'm so thankful to have Jonathan and Lisa here today from Orr Reno, PA, giving us a presentation. Thanks, guys.
Okay, good morning, everyone, and thank you for joining us. If you've been on these webinars before, welcome back, or welcome to anyone who is attending for the first time. Jonathan and I are going to be talking about some liability risk management issues as you all are reopening for business. And if I can make this PowerPoint work here, the basic overview of what we're going to cover is first the Safer at Home order that was issued yesterday. Jonathan is going to be talking about that. And then some tort liability risks. Those are things like negligence that you might hear about, those kinds of issues to watch out for as you're reopening. Briefly, some contract-related issues that you may be facing either because you haven't been performing under a contract, for example, paying your lease, or you're dealing with somebody else, a counterparty who hasn't been performing their contract obligations during the pandemic. Briefly on some legislative efforts that are out there to try and address liability during in the aftermath of the pandemic. And if we have time, this is sort of an ambitious agenda here, I'll touch on some bankruptcy issues to watch out for, either from your own perspective or from the perspective as being a creditor in a bankruptcy. So with that, let me turn the floor over to Jonathan.
Morning, everybody. As Lisa said, there was breaking news in the form of an update to the universal guidelines that was issued through emergency order number 52. You can access it through the covidguidance.nh.gov website that's referenced at the top of the slide. And this is guidelines that apply to all businesses and organizations and that are deemed essential and that have remained open, or those that are in the process of reopening all or a portion of their businesses. And the guidelines take effect immediately. And I think it's important to underscore that these guidelines, I think frankly provide great practical recommendations in terms of systems to implement and certain changes that should be made in your workplace or place of business. But they also are going to be important from a risk management standpoint because they really kind of set the stage for what would be considered reasonable practices and therefore are relevant to liability issues. These guidelines, interestingly, provide some guidance for both the employers as well as the expectations that are placed on the employees. The guidelines are based on recommendations that come from the Centers for Disease Control and Prevention, the Equal Employment Opportunity Commission, and from the Occupational Safety and Health Administration. And the universal guidelines are, I think, roughly 5 pages of directives, but there are also industry and business-specific guidelines that must be followed for certain segments of the business community. And so you'll want to start with the universal guidelines and then drill down for for your specific business guidelines to see what those unique requirements are. I'll just give a quick general overview. You can review, again, I'd encourage you to review the guidelines for yourself, but they establish requirements for the monitoring of employees and screening employees when they show up at the workplace every day. It talks about requiring employees not to be at the workplace and to stay home if they're exhibiting any symptoms of COVID-19. The guidelines also cover what should be done to handle those employees who exhibit COVID-19 symptoms in the course of the workday at the workplace. Also provides very specific guidance on what should be done in terms of hand sanitizers and other sterilization product that should be available throughout the workplace to both customers and to employees and to third-party vendors and independent contractors who your business works with. Guidelines also talk about developing certain policies and plans for your business that would then be followed. And they also give directives in terms of planning and changes that can be implemented to reduce the probability of the spread of COVID-19 in the place of business. I'm going to talk about this later in my slides, but this would include addressing common areas, implementing new policies for how frequently the premises would be cleaned, reducing the shared use of communal equipment like a photocopy machine or telephones, and all of those issues. And again, I mean, I think it goes without saying that the issues that one faces in a traditional office setting are very different from those that would be faced in a restaurant or at a public swimming pool. And so the devil is really in the details. And so each of you really has to focus on that specific directive given for your line of work in order to make sure you're in compliance with the universal guidelines as well as those specific to your business. Why don't we flip to the next slide and maybe we'll get into the universal guidelines more in the course of the questions. But again, this is first of all critically important for the health and well-being of society in general, and also for the safety and psychological comfort of your employees and invitees and others who come to your place of business. I think this is also important for your business to have in mind as you're trying to strategize and figure out how to keep those who come into your place of business safe. And it's, I guess, in your enlightened self-interest to be concerned about ways to reduce your potential exposure, your businesses, to a negligence type claim for contributing to the spread of COVID-19. So this is the people that we're focused on are patrons and customers who might claim that they came to your premises and got sick, whether it be from a surface or physical objects there or through exposure to your employees. This also covers third-party contractors who might claim that they acquired COVID-19, contracted it by virtue of contact with someone or something at your workplace. The workers' compensation bar makes employee claims not an issue in terms of liability. So really the focus is the third-party contractors and also those invitees, those customers and patrons who come to your place of business. I think beyond the matter of exposure that could arise from one of your vendors contracting COVID or being exposed to your property, I note that it's important for you to consider your agreements and contracts with them. And that's for two reasons. Number one, you want to consider the effect of any interruption in your business on your contractual obligations and duties under that contract that you have with your vendors and suppliers. But I think it's also a good occasion. I mean, I think the last several months have probably been all the occasion each of you have needed with your business, but it's an opportunity to assess business continuity plans and how you can ensure the delivery of services and product that you need from your suppliers during these unique times and going forward. And people, when you see the video footage on CNN of people gathering in close quarters in the Ozarks at water parks and You see protests where people are out and about without masks, and certainly there seems to be a greater degree of comfort in these summer months, and we all kind of come out of our hiding places and enjoy the outdoors this time of year. But it'll be there's fear of the second wave that could be coming, and so I think this is a perfect time to be thinking and planning ahead for what might happen in the months to follow. Lisa, I'm ready for the next one. So the standard of care. So the ordinary negligence standard on a claim is that of a reasonable person. What would a reasonable person do? That really determines whether a business is negligent and whether it satisfied its standard of care and the duty it owes to those to whom it owes a duty. And the standard of care, I think, in this realm will be dictated largely by the CDC guidance, the OSHA guidance, executive orders that come, like the executive order that I referred to earlier, the universal guidelines in New Hampshire, and as well as federal directives. And again, industry-specific guidelines will also set the standard for what is expected of your business and what the baseline. It's important to track these standards and to use them and to have them guide the company policies that you implement and that you design and then implement and put into effect. On the plan front, before you reopen, you really need to show that there was a coordinated and strategic and deliberate attempt to prepare and have everything set up so that your place of business is safe for those who come into it. That plan should address such things as your cleaning standards, both prior to opening each day and prior to opening in general, and ongoing throughout the operation of your business on site at the premises. It also includes, as I referenced from some of the universal guidelines, the practices and the requirements you'll put in place with regard to your employees. It should also cover social distancing within the workplace, and that's twofold at least. That includes, the spacing of your employees, as well as the ways that your business will plan to avoid situations where, 4 months ago, we used to congregate around the coffee machine, and your plan should have in mind ways to ensure that people maintain separation at all times and are reminded of that directive. And signage is a good component to have that you address in your plan, because really the plan it's the framework and it's an important playbook for how your business is going to operate. But you should also know that the plan is, if there were to be a claim, the plan is kind of Exhibit A in terms of really demonstrating the preparations that your business went through before you opened up, and then the high standards that you had for operating. Next slide. So again, relative to employees, there are 10 suggestions that I flagged, and these are things that I recommend you address in your plan and then implement in the workplace. That includes having rules that set expectations for no personal contact, no people going into the safe space of other employees without face masks, no item sharing policy, no use of communal staplers, no use of each other's phones. I mean, it's a strange era we're now in. It's hard to believe that 4 months ago we wouldn't have thought twice about borrowing someone's set of scissors, and now we need to be concerned about that. Number 3, reorganizing your floor plan. I think gone are the days, probably at least in the near term, of the open floor plan with pods. I think I'm sure many of you in office settings have adjusted and have created more space between workstations, and that's something to have in mind for minimizing those common gathering areas, whether it be around the coffee machine or around the copy machine or places like that. Modifying the break rooms. An employee cannot, employees need break rooms for their mental comfort and for their productivity. But we can't have the break room be the central meeting place where all of a sudden all social distancing guidelines fall by the wayside and people are congregating. But you do need to make those spaces available so people have a place to retreat and to get a reprieve from their workday. So steps should be taken and consideration should be given to how to modify break rooms so they provide the functional space that your place of business needs, but they do so in a proper and safe and well thought through way. Hand sanitizing stations throughout the office building, adjustments to the cleaning expectations for those communal office equipment, or if it's a retail setting for the counter, that would include I'm throwing out a time, but hourly or every 2 hours having a wipe down with a sterilization product of those high touch areas and surfaces. Face mask expectations for your employees in terms of wearing one when they use the restrooms and when they're walking in common spaces. Reducing and maybe even setting a clear directive in terms of how many people can be in a closed conference room, or how many people are allowed in your retail business at any particular given time. And then lastly, considering adjustments to the traditional 9 to 5 and maybe having certain people work certain days, or adjusting, having different shifts, but different ways to accomplish the work that needs to be done, but spacing it out so that people can maintain the space they need. It's also important, once you have this plan, to monitor compliance with it and to track compliance with it. But I reference this as, I refer to this as a double-edged sword. And the reason why I do that is because it's wonderful to have a record showing that you've actually abided by the structure you put in place. The downside is I've had many cases where there are checklists and logs that need to be completed showing that X, Y, and Z were done at particular times on particular days. And when someone forgets to fill out the log sheet, that's not very helpful evidence for that company. It shows kind of a lack of responsibility, and it can be used by a plaintiff to suggest that they weren't even following their own expectations for their employees. So I think that's something that should be considered. But I do think that having logs that show a commitment to your plan can generally be helpful, provided you're following through. One issue that I think bears emphasis is the fact that causation might be difficult to prove if someone were to make a claim of contracting COVID-19, and that's just because of the latency of showing the symptoms and the fact that some people can be asymptomatic. I think it really could be very difficult for a plaintiff to establish a point of origin. If someone, I suppose, has been reclusive and has only gone to limited public places, then maybe they'd have an easier means of pinpointing the source of contraction. But obviously, it's as we go about our days, it's hard to say whether it was touching that gasoline handle at the gas station, or whether it was when you forgot where you were and put your hands on the counter at the grocery store. But anyway, it'll be interesting to see how courts handle that and what happens in terms of causation defenses about how do you really know that you contracted COVID from being in this particular place. Another idea that I reference is the concept of liability releases and waivers. If you've gone to summer attractions, if you've gone to a ski area, if you have a child who's participated in youth sports, I'm sure you're familiar with the release. And releases are generally enforceable as a matter of law here in New Hampshire. And part of that is there is a very specific criteria that the court goes through in analyzing the enforceability of a release. But generally, one has the option of either partaking in the activity to which the release applies, or choosing to pass. Most things are volitional and not. You don't have to go to the amusement park in the summer. It's a choice you make, and if the release is what the amusement place requires for admittance, then that's the choice you make when you decide to sign that and initial it when you buy your ticket. So anyway, I raised this because it might be something that your business considers. There are obviously multiple considerations that are not just legal and risk management considerations. There are also perception and whether that would be off-putting to your customers, but it's one possibility and something that you might want to explore. Next slide.
I'll just throw in here, Jonathan, that I was asked to review such a release as that when the pandemic first got going in late March. And it was by a customer that was contracting with a subcontractor to come in and do service at its facility. And the customer essentially was saying to the subcontractor, if you're going to come in, you don't have to, but you need to certify that your employees will be following all the CDC guidelines, that they will assure us that they are not sick, and so forth and so on. So that it was essentially I would call it almost an indemnity agreement where the business that was seeking the subcontractor service was demanding from its subcontractor assurance that they were going to be handling all the COVID related issues and that they would not be liable if one of the employees of the subcontractor got sick during the course of employment of the job. So something to consider if you have the type of business where that would make sense.
Thanks, Lisa. So yeah, next slide. So we've covered, I think, a good chunk of this, but I'll just quickly go through it. That considerations to have with your employees, and this is both to alleviate their concerns and their mental comfort with being in your place of business, as well as to, of course, provide greater safety for them and to help with their well-being. That we're all ever mindful of the physical social distancing and physical distancing needs. So there are, you can see the bulleted suggestions there. In certain lines of work, telecommuting is a possibility. In others, it's obviously just not feasible, but there's a strong recommendation and a lot of guidance that has been published that suggests that where it's possible to telecommute, it's strongly encouraged. And I think the universal guidelines, if I'm remembering correctly, touch on that. There's the screening requirement that the universal guidelines put in place relative to screening employees upon their arrival at your place of business each day. And other considerations that frankly can really be matter specific and probably are really matters to address with an employment law lawyer. Would be, the accommodations that might need to be made because of someone's unique circumstances, because of a family member who has contracted COVID-19, because of maybe an employee's heightened sensitivities, whether they be medical or, fears. And so, there are a lot of issues that can arise in the employment context that will need to be considered, and along as part of those, there are reasonable accommodations requirements under the Americans with Disabilities Act, and so there are responsibilities that the employer has to assure reasonable accommodations of employees when required to do so by law. Lisa, I don't know if you want to add more on some of the employment issues.
If folks have particular questions, feel free to put them up. I know that the Chamber has other webinars in its archives that deal in very much more detail than we are covering here about employee issues and the extended leave, family leave considerations and whatnot, in terms of a pure employment law context for all of this. So it hadn't been our intention to cover those, but we can certainly field questions and give it a go if you have particular questions. But I think the important takeaway here is that to protect yourself from liability, you'll want to be going through these types of employee screenings, have the temporal thermometer that checks your temperature on your forehead without touching anything. when you come in. I did it this morning. I'm in my office right now, and we've put these kinds of practices into place already. It's not hard, and someone sits there at the front desk and asks you the 5 questions that are recommended. Those, does it seem like this is overkill and crazy and a real hassle? To a certain extent, yes, but the importance of this from your liability perspective can't be underscored enough. These are the types of practices, if you're following them, that will limit your liability. And please understand that the plaintiff's bar is actively bringing COVID-related lawsuits now. And that is all over the legal press and in discussion with colleagues in other states. It is very clear that the people who are looking for opportunities to sue you, the plaintiff's bar is out there trying to do just that. So we are, we want to make sure you understand that this is very important. This isn't just, oh, I have to do this because some politician came up with it. No, this is actual risk management that you need to consider from that perspective, if nothing else. Let's take the politics out of it and look at it from how to protect you if you get sued. And I think maybe the other thing you need to take into consideration is, most businesses think, well, if I get sued, I just turn it over to my liability insurance carrier and they take care of it. Most liability policies have virus exclusions in them and will not cover claims related to viruses. So it may, you may have a special policy where you bought that coverage back, but most of you, if you haven't looked over your liability policy, I urge you to do so, because it probably has a virus exclusion. They became the norm back in the early 2000s with the first SARS epidemic, where there were, outbreaks around the country, and the liability insurers got hammered with claims related to contracting that virus. And they put these exclusions in, so they've probably been in your policy for the last close to 20 years, and you didn't really focus on it because nothing like this has happened since. So you may be flying without insurance coverage for these types of lawsuits. So it's very important that you take some proactive measures here to protect yourself.
Thanks for that, Lisa. That's really helpful. I think those are really important points that, our audience will appreciate. I think we're ready for the next one. So the PPE could be something more extreme than a face mask. It might just be the face mask, but that's a requirement. You should take a look at and likely update your employee illness policies. And Lisa talked about the paid sick leave and extended family medical leave issues. And these are unique times where employees who have young children who formerly relied on summer camps and daycare facilities to care for their children during the workday no longer have many of those. Although I think camps are one of the businesses that are opening, I believe, in July. But be that as it may, there might be accommodations that an employer needs to make relative to an employee's needs to work from home, given childcare constraints. Next slide.
And then that turns over to contract issues. Let me touch, obviously the most important contract I've probably mentioned is your insurance contract. So take a look at that if you haven't, to find out whether you've got protection for COVID-related claims. But from a contract perspective, most of you, probably all of you, have contracts, whether it's with vendors, suppliers for your business. And it may very well be that you yourself are trying to get out from under a contract, or you're concerned that your counterparty is trying to get out from obligations under a contract. What do you do? There are those who have not been paying rent or CAM or their taxes because of slowdowns in payment. Obviously, we've been dealing with event cancellations and postponements. Do you have to pay back the deposits if you're one of those venues? or can you require the parties to reschedule their event? If it's not happened yet, can somebody sort of preemptively get out from having to pay a scheduled deposit, something like that? And then you've probably heard the term force majeure thrown around as a way to get out of contracts. Let's just look at these issues a little bit. There are essentially 4 legal theories that might permit what I call a penalty-free termination of a contract or excuse your obligation to perform under a contract. There is this idea of force majeure. That's an actual clause in a contract. If your contract that you're looking at doesn't have a force majeure clause, it doesn't apply to your contract. And then there's 3 common law doctrines that I list here. One's called commercial frustration, sometimes also referred to as frustration of purpose, impossibility of performance, and impracticability of performance. And I'll break these down for you over the next few slides. But what I want to point out right at the beginning here is having an inability to pay, whether it's you not being able to pay or your counterparty claiming that they just don't have the money to pay, is not good enough. Because the pandemic happened and you're short on cash does not excuse your contractual performance just in and of itself. In essence, these legal doctrines are not designed to get you out of a bad deal. If you negotiated something for yourself that turns out to have not been to your best advantage, the law may not help you in those circumstances. But let's look at what might apply. Force majeure literally translates from the French as superior force. And these, as I said, are clauses in contracts. So if your contract doesn't have something like this, even if it doesn't call it force majeure, there might be, some other term that means essentially the same thing. If you've got that kind of contract term, you have to look at what it provides for. And I gave an example on here, and we'll send you these slides after so you can take a closer look. But what this particular provision that I took out of a contract that I was working with for in a destination meeting, a meeting that was going to happen in another state right during the time of the pandemic. The types of events that this clause covered were unavailability of transportation that prevents the occurrence of your meeting, acts of God, war, civil disturbances, accidents or labor disputes, and then they had an exclusion if you're booking for somebody else. The law or the courts interpret these clauses very strictly. So the types of things that's an act of God is not generally considered a pandemic. It's more like a hurricane, tornado, that sort of thing. War, civil disturbance, those types of activities are strictly construed. So a pandemic may not apply. There are force majeure clauses that include pandemic, and that again resulted from the SARS epidemic from the early 2000s. So you may have that kind of provision in your contract, but you can certainly assert that a pandemic might fit under these different types of categories. But the cases that I've read that interpret these clauses probably would not necessarily consider a pandemic as falling under the force majeure clause. But what about frustration of purpose? These common law means judge-made doctrines that might apply if there is no force majeure clause. And I termed it here as a gap filler. And that's essentially, the courts have looked at what is fair if particular circumstances have occurred that make the purpose of the contract, just not able to be fulfilled. And in this case, frustration of purpose exists if circumstances destroy the reason for the contract. And I give you an example here to try and explain what I'm talking about. In my travel to Florida for a meeting in mid-April, example from the force majeure clause, let's assume that that you were planning on a business meeting at Walt Disney. Well, the executive orders in Florida, which I can confirm, in Florida, they closed all the Walt Disney theme parks during the pandemic, at least through the month of April when I was looking. The purpose of this contract with the Walt Disney Resorts is for your group meeting at Walt Disney so that your meeting attendees can enjoy the theme parks. The point of the contract, a meeting that allows participants to have this leisure activity, has been frustrated by the pandemic. This is the type of clause that, or the doctrine that could apply under your circumstances to terminate the contract and allow you to get back any deposits that were made under the contract. And in fact, Walt Disney very willingly did that for the client that I was working with because they acknowledged that the purpose of the contract was frustrated. So how is that different from impossibility of performance? Well, impossibility of performance is when everyone's counting on a certain thing or circumstance in the contract, but something unforeseen happens, making it impossible to perform. Let me give you an example. You're a painter and you contract with a customer to paint a house, but the house burns down before you get to paint it. You can't, it is impossible to perform the contract because there's no house to paint. That's impossibility of performance. Might that apply to the pandemic? Possibly. Impossibility generally implies that one or both parties cannot perform the contract. Many contracts could technically be performed. Like in my travel to Florida example, the client could technically have gotten to Florida and technically had the ability to pay for a hotel. And a certain number of people anyway could technically have stayed at the hotel. So it wasn't impossible to perform the contract, but in that travel example, the purpose of the contract was frustrated. Impossibility, maybe, if you had a business that was shut down, or you were working with a business that was shut down during the pandemic, so that you couldn't hold your event because executive orders prohibited it, it might apply and that might get you out of the contract, or might get your client out of the contract if you're on the other end of that. Impracticability of performance is another nuance on all this. Again, you're counting on a certain thing, circumstance of the contract. Something unforeseen happens that makes it impractical. And generally that means really expensive or really difficult to perform. Example, I've been hired to take gravel out of a piece of property owned by the client. What neither of us knew is that there was a huge amount of ledge that was going to have to be blasted. So I can still get all the gravel out of the property, but it's going to cost me 10 times as much as we anticipated because no one knew about the ledge. That's what makes a contract impracticable. The courts would acknowledge that neither party understood that the event was going to happen. It's now hugely expensive, or maybe in the case of COVID, unreasonably risky to perform the contract. That might get you out from under performance under a contract. Again, a nuance on these themes here, and I think you get the idea. What we're talking about is, has COVID made it unreasonable essentially to perform the contract? For example, you were going to have close proximity to somebody in order to perform under the contract, but and your system virus, and it's just too dangerous for you to perform the contract. You might be able to get out of it there. But what if your contract is paying a lease? You can't get to the premises in the shopping mall because of the shutdowns, or because of, landlord has made certain assumptions for everybody in the strip mall or whatnot. One of these doctrines might apply and it might not. It really depends on your circumstances and whether actions that were taken during the pandemic create one of these issues for your contract. Pitfalls that I want you to be aware of, if you say, oh, that's a great idea, Lisa, let me write a letter to the other party and invoke the one of these doctrines to get out from under my contract. Be careful what terms you use, because most states recognize these theories, but whether you say you're canceling the contract or terminating the contract, these can have special terms, because some contracts have cancellation provisions that might allow you to, for example, cancel your event, but still have to pay penalties for canceling before the event happened. So it's not that you want to cancel the event, you want to terminate the contract. So be careful with what terms you use, and you may want to run by any letter that you want to write to the other party by whoever your legal counsel is, just to make sure that you don't inadvertently say the wrong thing that allows the other party to take advantage of provisions in your contract to make you pay something. If you breached your contract prior to the pandemic, and that's what you want to use as your excuse, the pandemic's not going to save you. These theories are designed to handle events that make it difficult or impossible to perform the contract, not get you out of a breach that you've already done. Practical strategies for you to consider. Is pandemic listed as a force majeure? As I said, read your contract. Does it affect the purpose of the contract temporarily or permanently? Because it may be that it's just a temporary stoppage of obligations under the contract, but the whole contract doesn't have to go. Does it affect your ability to perform? Those are the kinds of things you have to worry about. And whether, quite frankly, you want to invoke a termination of the contract. Is this an important client? So you have to think of it from business relationship standpoint, whether you want to try and cut your damages, or do you want to negotiate, for example, to try and minimize your damages under the contract so that you can preserve the relationship going forward, recognizing that some business relationships are more important in the long term than trying to recoup 3 or 4 months of losses under a contract. So things to consider. We're not suggesting that just because you can try and terminate a contract that you should actually go forward with it. So think that one through. Let me, keeping mindful of the time and the fact that we've got a couple of questions starting to queue up here, could the legislature protect you by passing some legislation that gives immunity to businesses as they reopen? The answer is probably not. It's being proposed in a few states, but the problem is it's likely a constitutional violation. It would violate the Contracts Clause, for one thing. We'll see where that shakes out, but the legal analysis I've seen of the types of provisions which are selectively giving immunity protection for COVID-related risks would likely face equal protection challenges. Why COVID risks and not some other type of risk, those kinds of problems. The plaintiff's bar will be very, very active in that. We talked about insurance. Can insurance coverage, can the legislature require insurance coverage? Because that's another area. As long as it meets constitutional balancing, yes. They have to establish a rational relationship between an important state interest and why the insurance industry would be obligated to pay. The problem they're going to run into, I think, is that it would cause premiums to increase dramatically, or it would bankrupt the insurance industry. So does that type of legislative effort lead to something that's feasible? That's probably not a great area either. We'll, again, see how this plays out. And there's been a few piecemeal efforts so far in the healthcare industry. There's been some in New Hampshire, I'll say the Attorney General has opined that there's an existing immunity statute that applies to emergency management workers who are dealing with crisis conditions that protect them for, the service that they're providing. And the AG says that applies to healthcare workers during the pandemic conditions in the state of emergency. So at least the healthcare industry is probably protected. The liability insurers and the BIA are supporting broader immunity protection to businesses reopening after the pandemic. And the BIA, I know, has sent a letter to the governor and leadership in the legislature suggesting that they do it. Again, I suspect that's going to be doomed to failure. But at the, and at the federal level, the Trump administration had been promoting it as part of further support packages. The Democratic leadership was not in support of it, so it was becoming a political hot button. We'll see. But don't hold your breath. Your best, right now, your best strategies are still personal risk management activities within your business. So might there be a legislative fix? Possibly. I think it's going to end up getting shot down in the courts, so we'll see. And quickly, so that we can get to some of your questions, I just want to mention a little bit about bankruptcy planning, because many of you are going to face, being probably for the first time in your history, creditors in bankruptcy, when parties that you've dealt with either as customers aren't paying you and declare bankruptcy falling out of the pandemic, or you yourself are thinking about it. Quite ironically, on February 20th, just as the pandemic was breaking, the Small Business Reorganization Act came into effect, which created a whole new category of small bankruptcies. They call it under Chapter 11, which is business reorganization bankruptcies, a subchapter 5. The CARES Act, which dealt specifically with the pandemic, modified the debt thresholds for people going into this very streamlined bankruptcy process that makes it easier, quite frankly, to qualify for bankruptcy and to get through a much more quick and streamlined process. Here's a slide, and I'm not going to read every bullet here. You'll have this if this is something that's important to you, or send me a question offline and I'm happy to walk you through it. But you have to have at least 50% commercial debt if you're the debtor, up to 7.5 million in debt. If you're higher than that, you're going to be in regular bankruptcy and you'll have to deal with the full set of rules that deal with that. Once the state of emergency is over, this debt ceiling is going to revert back to about 2.7 million. I mean, and you look at these weird numbers, 72725, 625. Why would they ever come up with such a strange number? It has to do with cost of living increases on benchmarks over time, and that's where they come up with these numbers. It's supposed to be a quick process, 90-day deadline to get this all done and over with and so forth. Again, I don't want to read through all of this, but understand that there will be a very streamlined bankruptcy process. If you're the debtor, you're going to end up stop paying bills. If you're the creditor, unfortunately, your counterparty is going to stop paying their bills. So keep tabs if you're the creditor on your AR, if you've got a client that's at risk of going into bankruptcy, and consider whether you can stop supplying more goods to them or services or whatnot. If you have the option of getting secured debt, that's important because you get a higher priority in bankruptcy. That means a mortgage on property to secure repayment, that sort of thing. There's a 90-day look-back period. That's important for creditors to understand, because if you got payments within the 90 days before your debtor filed for bankruptcy, the trustee may seek recovery, or most likely will seek recovery of those payments, and you'll have to pay them back into the bankruptcy estate. You'll need to file a proof of claim, generally, to establish your right to get money back. And to the extent that you provide goods or services to the debtor within 20 days before the petition or after the petition for bankruptcy is filed, you can ask the court to consider that a high priority administrative expense, because essentially you're providing goods or services that allow this business to keep operating. And that gets priority in bankruptcy. So that's a provision you'll need to keep on top of, because you have to make a specific request for administrative expenses and not just rely on a proof of claim. Trustees can challenge anything that you put in there, so it becomes little mini litigation within the larger bankruptcy, so just be aware of that. The very important thing that you need to be aware of if you've never been through the bankruptcy process with a client before is that there's an automatic stay of all collection efforts. That means once the petition's filed, you must stop all collection efforts or you will be in violation of federal law. And the trustees can be very aggressive at coming after you for continuing to ask for payment. So be careful that if you have automatic dunning emails that go out about you need to pay your bills or something like that, that once you learn about a bankruptcy, you stop all that because it can run you into real trouble. And you may end up paying more than the debtor owes you in fines and penalties for taking those actions. If you have a contract with a debtor, example, you're a landlord, the trustee can decide whether to continue that lease or reject the lease. And unfortunately, until that decision's made, you're not going to be able to offer the premises to somebody else. But after the petition, if somebody is going to retain, if the trustee insists that you maintain the lease premises, they're going to have to pay rent. If they reject it, there will be no more rent paid. So just issues for you to consider. Let's take a look at the questions we've got here. Would impracticability of performance be applicable to a group travel arrangement to Europe in the fall if the pandemic spikes again? The answer is possibly, and more than one of these theories may apply. Ironically, the closer you get to the date of your trip, the stronger your claim is going to get. Right now, it depends on which country. Monitor the country because they have different opening guidelines for when, particularly travelers from the US are going to be let back in. I know, for example, for someone I was looking at a planned trip later in the summer, early fall to Norway, and it turns out they're not opening their borders to US travelers to at least August 20th, which dates obviously can get pushed back depending on whether there's a spike in the pandemic. But in terms of your particular question, to Europe in the fall, possibly. You might want to be monitoring this with, I don't know if you're going through a travel agent or you're doing this yourself through the airlines. Just keep on top of it. Hopefully, if you've already purchased airline tickets, it was during the period of time where the airlines are willing to change the dates on tickets, even if they're non-refundable tickets, so that because they're recognizing the pandemic and they'd rather have people keep their deposits with them. Obviously, they want the money in their bank accounts rather than paying back even some portion of the ticket. Even if it's minus a penalty provision, they'd rather have your full ticket. But absolutely, this legal theory might, and frustration of performance might apply. And it could be impossibility of performance if the country where you're headed is refusing to allow US travelers. So yeah, keep tabs on that. That's it so far for questions. And Jonathan, any last minute points you want to make before we turn this over to Emily?
No, I don't have any, and thank you all for participating. I guess if you have a burning question, here's your final call. You can click the Q&A button on the bottom of your screen, and I guess Emily has something she wants to add in the meantime.
Let me stop sharing my screen so Emily can take over.
All right, so again, if you have a question, we have just a few minutes, so you can type that in with the Q&A portal. So you'll just tap your screen or move your mouse a little bit and click on Q&A to submit those. I do want to let you know about a couple things going on with the Chamber. Again, this webinar is recorded. If you signed up for to attend today, you will receive a copy of it via email as well as those great slides. So a couple other things going on. The deadline for the Leadership Greater Concord Class of 2021 is this Friday. So if you've been thinking about applying, you may want to do so now. There has been a slight adjustment to the program. Instead of an overnight orientation, there's going to be a day-long orientation. So that's going to make it safer for everyone attending. So if that's been holding you back, apply now. Also, we are accepting nominations for our Pinnacle Awards. So if you would like to support a business right now, this is a great way to do that. So again, any of this information can be found on our Chamber website. I think I saw another question pop up on screen. Do you guys have time to answer this last one?
Sure. And the question is, can an employee be in trouble if they are not comfortable returning to work? The safer at home guidelines, and Jonathan, you're more up on those, you studied those more closely than I did, but as I understand it, the guidelines would suggest that if an employee is not comfortable coming back to work, that you try to make reasonable accommodations for them to work from home if possible. Does that make sense?
I think that's right. And the guidelines do talk about the obligation of an employer to remind employees of the provisions of the federal Families First Coronavirus Response Act. And that allows for paid sick leave or expanded family and medical leave for certain specified reasons that could include self-quarantining or seeking a medical diagnosis for COVID-19 treatment. In terms of whether that, I don't think that extends to a personal comfort situation, but.
You know, if you want to email us offline, we can get you a better answer, because neither Jonathan nor I are employment specialists, but we work with some who are much more versed in these questions. And as I said, there was I think I'm correct, Emily, that one of the prior webinars, or maybe more than one, dealt with these employment-related issues specifically. And I know on the Orr Reno website, there are some COVID guidance for visitors to our website that probably answer this more specifically. My understanding is that you're supposed to try and seek reasonable accommodation for these folks. But if you want to just shoot us, either one of us, an email, I'm lwade@orr-reno.com, Jonathan's j.eck@orr-reno.com. We'll get you the specific answer to that question.
Yeah, to follow up on what you were saying, we have presented some webinars on employment issues, and they may have valuable information for you, but things are changing so rapidly and people are returning to work now with kind of new rules in place. So I would highly recommend that you get in touch with the Orr Reno team there so that they can give you the most accurate information.
Okay. Thank you all, and have a wonderful rest of your day.
Yeah, thank you again to our great presenters and for Orr Reno for sharing this information. Thank you all for coming.
Okay.